A very warm welcome, everyone. Thank you so much for joining us this morning. We have an amazing session planned for you. We've had a phenomenal response to this, so clearly this is a topic that you all want to hear about. Very, very honored to be joined today by Tulin Hamit and Louise Jones, who are both solicitors at Collyer Bristow. Collyer Bristow is our legal partner, and they have been now for the second year in a row. We are really, really honored to partner with them. I love their approach to how they work with clients. They particularly embrace the creativity and innovation that comes with working with entrepreneurs. So it's a really tailored approach, and we are very, very honored to be partnering with them. Tulin is a partner at Collyer Bristow in their estate planning and tax team. And I know that you particularly cover international matters, Tulin, so it's great to have you with us today. Thank you. And Louise is an associate in the team, also working with estate planning and tax. And I know that you work a lot with families around planning their wealth and their succession and understanding what happens to their assets and how to manage them effectively. Thank you so much for joining us, both of you. It's a great honor. And I know that you have some brilliant content planned for us today. Just for some housekeeping, please do keep your microphones on mute as we go along. There's going to be plenty of opportunity to ask questions. So if you have questions, just pop them in the chat and we'll either integrate them as we go along, but we'll also have a block of time for questions at the end. So without further ado, I'm going to hand over to you both to start the content with us. I'm going to be controlling the slides, so just let me know when you want me to move to the next one. And I can see we've still got some people coming in. So for those that are joining us, we're about to start. Welcome. Thank you very much for coming along. And a reminder that if you've got questions, please just put them in. We really would like the session to be as interactive as possible. Brilliant. And just keep your microphones on mute. Right, Tulin and Louise, can I hand over to you?
Yeah, thank you so much for having us this morning. It's really a pleasure to meet with everyone. And today we're going to be talking about sort of an introduction to estate planning, a kind of beginner's guide where to get started, because I think a lot of people, you know, they're so overwhelmed by what could be done and what needs to be done. They sort of don't know where to start. So I just wanted to run through sort of my tips on where we can start. So probably the main thing is, you know, people think, when is a good time to start thinking about what you want to happen when you die? Is it when you get married, when you have children, when you buy a property or receive an inheritance? For some people, it's when they start a business or sell that business. And then some people really put it off until retirement age. And the simple answer is no. All of the above. You know, each and every one of these events in life and some others are the right times to start thinking about getting your affairs in order or reviewing what arrangements you already have in place. I mean, all too often, I meet clients who are aware that they need to sort out or review their wills or their lasting powers of attorney or get some proper estate planning advice, but they're always too busy. They need to see how some investments play out or how their business grows. And some people just don't want to think about it. They don't want to think about death, which, as they see it, is going to happen, you know, far and away in the future, and we don't need to think about it now. And unfortunately, you know, the truth is that we need to think about death. If you could just change the slide, please, Michelle. I think one of the really shocking statistics is that, you know, 65% of adults under the age of 50 do not even have a valid will. And, you know, unfortunately, death is depressing, but it can be empowering to tackle that issue head on and make sure that you've provided for who you want to provide for and that all your affairs have been put in good order. Probably the best place to start with estate planning is with a will. You know, do you have one? Is it up to date? Does it reflect your current wishes? Do you make a conscious effort to check back in and review it every 3 to 5 years or so? Next slide, please, Michelle. A wise person once said to me that there are 4 key pillars in private wealth. The first is your assets. The second is the beneficiaries, which is usually your family. The third are your personal wishes, and 4 is the general economy. And at least one of these pillars undergoes changes every 3 years. And I think this really underlines how why it's important to keep your will and estate planning under regular review. It's not something that you should do, put away and forget about for the rest of your life. It's really important to check back in every few years and just make sure that everything makes sense and it's exactly as you want it to be. Probably the most important thing to think about is, if you don't have a will, do you know what's going to happen to your estate after you die? Next slide, please, Michelle. So if you die without a will in England and Wales, the intestacy rules kick in. And after you've paid, your executors have paid taxes and administration expenses, your estate is distributed to specific classes of people. And in practice, this is what it might look like as it's set out on the slide. If you're married and you don't have children, everything will go to your spouse. If you're not married and you do not have children, everything will go up a generation to your parents. And if they've both died, it will be shared between your siblings. If your siblings are no longer alive, it'll be shared between any nieces and nephews. If you're married and you've got children, the first £270,000 of your estate will go to your spouse, and the remainder will be split into 2 equal pots. The first pot will go to your spouse, and the second pot will go to your children. If you've got more than one child, it'll be shared equally between the children. And this might not be what you want. For example, if your parents inherit your estate, it doesn't make tax sense to send assets up a generation for the assets only to be subject to inheritance tax on your death. And then again, when your parents die, which given the generation above you, it's not likely to be in the too distant future. If you're married and you've got children, there's always a risk that your spouse could remarry and that your estate could be diverted away from your children. And that might not be what you want. And also, this is quite an interesting one, that, blended families are really commonplace nowadays. And a lot of people have both full blood and half blood siblings. But under the intestacy rules, only full blood siblings benefit from your estate. So half blood siblings will not receive anything at all. And that might not be what you want. You might want to treat all of your siblings, full and half blood, equally. So I think you can see now why a will really is essential. Next slide, please. There's other reasons why it's essential as well, apart from making sure that people get the assets that you want to receive them. The most important point is that it ensures your wishes are carried out and the people you want to benefit from your estate actually do. It allows you to appoint people you choose as executors and guardians of your children. And it allows you to incorporate some protection for young children so that they're not exposed to large amounts of wealth at too young an age. And it also allows you to make the best use of tax planning opportunities.
Louise, I think while you were talking, sorry, there is one relevant question came to our chat box. I don't know whether, Michelle, would you like you to Louise to have a look at it?
Yeah, I can have a look. Let me just have a look.
It's quite
so Penny's asked on slide 6, a question on slide 6, what happens for a couple with children but not married?
So in that case, your estate would pass to your children and it would be shared equally between your children. So your partner, your unmarried partner, would not receive anything. And that might not be what you want. Perhaps the children are young and they're not. You might want to make sure that the assets pass in a sort of structured way so that the children are not exposed to large amounts of wealth at a young age.
Okay. Penny, does that answer your question? Let's give us a thumbs up.
Thanks.
I had a question as well, Louise, around this slide. What is an executor, and do you have to pay them? Like, how do we choose who should be the executor of our estate?
Yeah, it's really a personal decision. I mean, some people, they choose somebody that's close to them, perhaps a spouse or a really close friend, to deal with their estate. And that can be for lots of reasons, perhaps because they trust them, they're close to them, they have an awareness of what the assets might be. But for some people, they don't want to do that. They just want to appoint professionals, so solicitors, for example, to take care of the estate. And I think it's really a personal decision, because, you know, in a difficult situation where you've lost someone that's very close to you, it can be quite an onerous task to then have to deal with the administration of the estate as well, on top of the grief. So it really is a personal decision. In terms of charging and costs, usually professionals would charge to administer an estate, but usually a layperson, a friend or a partner would not charge. But there's always the option, you can always appoint a layperson, so a friend or a partner, to act as your executor, and they can consult with solicitors and professionals to help them to administer the estate. So that might be a good option, and it's an option that we do see quite frequently.
And I will also add that because I work with lots of international clients, they prefer the professionals rather than the friends, because they might not have a very close friend. Because if they come here for the last 5 years, 10 years, they haven't established a long relationship to trust somebody. So generally for all my clients, I'm the executor.
Okay. And when we're talking about guardians, because I know there's a lot of confusion around this, what is the definition of a guardian? And again, how do we choose that person or those people?
I mean, it's such an important thing. And I have clients who perhaps have wills in place and then have subsequently had children and haven't really given much thought to it. Excuse me. But it's really important to, if you've got children that are, you know, under the age of 18, to appoint guardians, because if you were to die and the other parent is also deceased, if you were to die together in an accident, for example, then it would be for the relatives or the close family to have to make an application to the court in terms of guardianship for the children. So that might not be what you want, and it's always just safer to be prepared to have a will that appoints specific people to act as guardians. And frequently we see our clients, they put in place guardianship letters of wishes, which might set out how they would like the guardians to raise the children, sort of religious wishes, education wishes. You know, perhaps if it's an international family, they might say, it's my wish for the children to be raised in a specific jurisdiction, if possible. So it's really important to cover this, to make sure that this is, you know, you put guardians in place in your will. And
I guess ahead of appointing them, you have to have that discussion with them, and
yes.
they have to agree to what your wishes are, because it would be a bit of a shock if they found out after you died that you'd said you wanted them to raise your kids, you know, in a certain way, and that wasn't what they had agreed to.
Yeah, exactly. It's always good to be very open and transparent, and it's such an important role as well. You know, usually it would be a close family member, maybe a sibling that would step into those shoes, but it's always important to be open, so that everybody knows what's going to happen. You don't want to have any kind of confusion after you die. You want to make sure that everything's properly in place.
Okay, wow. That's really helpful, because I think I was always confused about the meaning of a guardian versus a godparent. And, you know, because I think culturally in some places a godparent is somebody who takes over the children or looks after the children when you die, but doesn't necessarily have any control over, you know, kind of the money, or how they're raised.
Exactly. I mean, certainly in the UK, a godparent is a religious role, that would be, their responsibilities are to bring the child up in the church, but not a legal role like a guardian.
And also, just before we move on to the next bit, is it advisable to have someone who's kind of an executor who's managing the money on behalf of the children, rather than giving that responsibility to the guardians? So for example, if your children stood to inherit a large sum of money, that responsibility wouldn't be theirs as well. Does it make sense to split that, so that they're raising the children, but the money's being administered by somebody else?
Yeah, I mean, certainly it's it's really, it will depend on the circumstances of the case. And I think, you know, when you have these candid conversations with people you want to appoint as guardians, you need to be open and transparent about money as well, because a lot of people might be a bit concerned. It's quite a financial commitment to take on children, especially if there's school fees involved. But if you are very transparent and make it clear that the financial resources are there, but you know, there's no specific rule. You can appoint someone as your executor and guardian, but you might prefer to leave it to the professionals to act as an executor, and then personal contacts to act as a guardian.
And also you can, because if the children are minor, and then you can create a trust in your will where you can actually appoint trustees who will manage the financial affairs, and the guardians will only deal with the raising up the child.
Okay. Yeah, actually, Penny's just asked a question. She's saying, how do children inherit money when you die? What is the default if you don't organize anything? So if you have nothing in place.
So basically, Louise, if there is no will to create a trust, and if the parents die when the children are minor, I suppose we are going to talk about the statutory trust option.
Yeah.
Okay. And then we've also just had another question about executors. Is an executor under any legal requirement to ensure that the estate is distributed under a certain time limit?
I mean, executors have responsibilities, so they have a responsibility to gather in the assets of the estate, to render an inheritance tax account, to make sure that the tax is paid, and any expenses and administration expenses and taxes are all paid. But really, in terms of time limits, there are no specific time limits, and it really does depend on the circumstances of the case. Sometimes, you know, I mean, I've been working on a probate for 4 years. It can take a long time depending on the complexity of the assets and the complexity of the situation. But generally, you know, we refer to the executor's year. So everything is generally, in most cases, completely dealt with within a year after death.
Okay.
And if the IHT needs to pay in the executor's year, so at least we need to know how much IHT is payable in a year's time. However, dealing with all the administration side and then obtaining the probate and then distributing, it might take quite a long time, depending upon how complex the estate is. Again, like one of my estates continued for 7 years. So it's because they had lots of assets all over the world. It was really difficult to find out where the person was domiciled. And it's, you know, some jurisdiction involves the court, not like the probate court, but the more complex court. So it takes time. And if there is some claims against the estate, then again, the process gets longer and longer.
So I guess to what you were just saying, Tulin, I mean, that kind of, as a parent, that would make me worry that if something happened to me and my children were still minors, or still needed to, you know, have their money administered on their behalf, that makes sense then to really make sure that your wishes are as clear as possible, so that the time doesn't drag and it doesn't land up taking 4 years. Because what happens in cases like that, where it does take a long time, but there are children that need to have money distributed to them, or
then we do like interim distributions.
Oh, okay.
So because children needs to be looked after, and also sometimes estate gets really complex because the deceased hasn't organized their financial affairs. This is again generally the case where the wife is one partner, I will say, is not all men's are the breadwinner. The one partner is working very hard, another one is dealing with the family affairs inside, and doesn't know what the other spouse financial affairs are. Then when the breadwinner dies, it's really, really difficult to find out whether they have a estate in the UK, or in my case in Turkey, sometime in the USA. Some monies and the portfolio comes out of the Sweden or Holland bank account. So by the time that we do the research and get the information and gather everything, it takes time. But when the person has the all their financial affairs written and share with the spouse or the executors beforehand, then the process takes quicker.
Okay, that's really helpful. And someone's actually just asked, what age is a minor?
Under 18.
Under 18. Okay.
Yeah. So, I mean, one example that I wanted to give, and I sort of touched on this already, is, you know, if you're married with children, you might want to make sure that your wealth is preserved for your children, and it's protected, and it's not at risk of being diverted away from your children should your spouse remarry after your death. You might want to safeguard the wealth and your children so that they do not receive large assets outright until they're sufficiently financially mature enough to deal with the responsibility of wealth. But you might want to make sure that they're provided for and able to benefit from the wealth in certain circumstances. You know, you might want to ensure their education costs are covered, cover cost of driving lessons and a first car. You might want to cover any costs associated with obtaining professional training and qualifications. So one option would be to leave your estate on trust, giving your spouse a life interest in that trust, which offers the best opportunity for tax planning, because it means that there will be no inheritance tax to pay on your death because of the spouse exemption from inheritance tax. But in this way, the capital of your estate is preserved for your children without incurring an inheritance tax charge.
Okay. Well, thank you.
I think I'm going to pass over to Tulin now.
Yes, just before we do that, someone just asked when a will can be challenged.
So it can be challenged within 6 months of death, and it's usually challenged under the Inheritance Act's provision for family independence. And it's usually circumcised. There's a certain class of people that can challenge the will, and the basis is that they've been financially provided for by the deceased in the period before death, and the claims are usually based on that.
Okay, great.
Yeah,
okay.
And also I think it's the challenge when we are talking about the challenging the will. There are two subdivisions. One is because you are thinking that you haven't been provided in the will, and the second one is whether the will is valid, or whether when he was signed it was signed correctly, it was witnessed correctly, whether there is any previous will, whether he had the mental capacity when he signed the will. So you can actually challenge the will under the two subdivisions. And the only provision which protects the unmarried spouse by way of the challenging the will under the Inheritance Act. Because otherwise the unmarried couple can have automatic right to the inheritance under the intestacy rule.
Okay, brilliant. We had a few more questions and things come in, but I think what we should do is I'll keep those to the end, because I think some of them are quite specific, and there might even be ones that you might need to answer in person via email afterwards. But let's move on, and we'll have some time to address those at the end.
Thank you, Michelle. Thank you, Louise. Good morning, everybody. Now I'm going to talk to you a little bit about inheritance tax. Do you know how much inheritance tax is likely to payable if you die? Inheritance tax is primarily a tax on the individual's estate on death. However, it can also arise on certain lifetime gifts. For example, gift to certain trusts or gift to companies. However, in this presentation, I will mainly focus on the inheritance tax chargeable on death. Our starting point is that the inheritance tax rate in the UK is 40%. And should you domicile in the UK, in other ways, in a lay terms, born and bred in the UK, or at least you have been living in the UK for 15 tax years, in the last 20 tax years, your worldwide estate will be subject to the UK inheritance tax. Non-domiciled individuals, i.e. wasn't born or bred in the UK and hasn't lived in the UK long enough, i.e. less than 15 tax years, will be subject to the UK inheritance tax only on their UK status assets. In the UK, everybody, whether they are domicile or non-domicile, has a nil rate ban allowance of £325,000, which is able to pass free of inheritance tax on their death. In order for this full nil rate ban allowance to be available, there needs to have been no lifetime gifts made in the 7 years before death, because lifetime gifts take first bite of the allowance. This rule prohibits people making gifts on their deathbed, basically, in order to reduce to their estate's inheritance tax liability. On the top of that, provided the certain conditions are met, everybody has a residential nil rate ban allowance of now £175,000 per person. This allowance is conditional on individual owning a residential property or the proceeds of a residential property, which they live in at some point during their lifetime, and leaving it to their lineal descendants, i.e. their children, grandchildren, and so on. So in order to qualify for a residential nil rate ban allowance, you need to pass your residential property to your children or your grandchildren, but you can't say opt to leave it to your siblings or your nephews or niece. Surviving spouse or a civil partner can effectively inherit the unused percentage of their deceased spouse partner's nil rate ban, as well as the residential nil rate ban, actually. This is because any transfer, I think this is really important, between spouses and the civil partners, either during the lifetime or on death, are exempt from IHD. Therefore, if on first death, everything goes to the surviving spouse, for which you need to have a will in place, then on second death, there might be 1 million exemption applying to the estate, of course, provided that there were no gift made in the 7 years before the death. However, it is important to be aware that there are certain conditions which need to be met for the full allowance to be available. So it is essential to obtain the proper advice on this.
Wow, I'm just shocked that it's 40%. I didn't know that.
Yes, that's why I started from that. It's the shocking news, and then every news will come less painful.
So Tulin, then in terms of this here, is your allowance then, if you were a property owner or you someone that lives, is it your nil band rate plus the residence nil band?
Yes. So the 500.
Okay, so you get that cumulative relief. Okay.
Yes, exactly. However, the Conservative Party said that we are going to increase the nil rate ban, and then they didn't increase the nil rate ban, but they created a residence nil rate ban. So, but they gave one thing and took with the other hand. So, residence and nil rate ban applies in a very, very certain circumstances. And in total, if your estate is over 2.3 million, please, if I'm wrong, please correct me. I think it is 2.3 million. Then you are losing your residence nil rate ban in full. So I think it's over 2 million.
Yeah, any estates over 2 million, the relief is gradually tapered away. So for every £1 and £2, the relief is taken away. So if you work out that the residence no rate band is 350 for a married couple, if your estate's over 2.7, it's completely been withdrawn.
Yes. And Michelle, somebody else said, what do you mean per person? I didn't mean by the per beneficiary, I meant with the per person who passed away.
Okay. And we've had another question about, I think it's around domicile. Does that mean that if you are a UK resident with 15 tax years and inherit assets in a different country from a parent, you have to include those assets in your tax declaration, even if you're already paying inheritance tax in that country?
No, in the UK, as a beneficiary, you don't pay inheritance tax in the UK, because in the legal sense, the estate pays the tax. So if you are think about I have been living in the UK more than 17 years now. If my parents pays, God forbidden, in Turkey, if I receive anything in Turkey, I don't need to pay IHT in here, because I am the receiving party, not as actually the person who is going to pay tax is my parents. And if they don't have any UK status asset in the UK, they don't need to pay tax in the UK. They will pay their tax in Turkey, then I will inherit it. And then I don't need to pay additional IHT in the UK. However, when I pass away, because I am domiciled in the UK, and because I inherit the asset from my parents, I will be the owner of those assets. My estate will pay UK IHT on the Turkish assets when I pass away, not when I receive.
Okay, that's great. And we've had another question. Is inheritance tax incurred on my pension?
Okay, we have been talking about this. Yes, and the answer is no. Yes and no. First of all, there is no general exemption on pensions, and however, since 2016, there are some flexibility to get into the pension tax. When I look at it, which to the pension from the IHT perspective, rather than IHT, income tax is payable. And if your pension policy is written on trust, then the recipient doesn't need to pay the IHT, but it doesn't mean that they will not pay income tax. It's quite a complex area, but if she wants to speak with me later on and explain her, and also there are lots of pensions. Some of them are regulated pensions, some of them are defined pension schemes, and depending upon how you contribute the monies to the pensions, the IHT consequences changed. But in basic, when you contribute for your pension, you don't need to pay IHT on that. If your employers contribute to pension, you don't have to pay IHT on that, or your employer. But when you passed away, and depending upon how those pensions are going to payable to your family members, there might be income tax rather than IHT. And if your pension pot goes to your spouse, is spouse exempt.
Okay, that's excellent. Thank you very much. Yeah, I think that's all the questions. We've got another 2 kind of questions, but I think I'll keep those for the end because they are both quite specific to the people that have asked them. So back over to you.
Yes, thank you. I think we are passing to the new slide, by the way.
Okay.
And now we have talked about how much the IHT rate is. Then we are going to talk about the options to reduce the IHT liability. So have you ever thought about lifetime giving to reduce your taxable estate? And what are the options available to you? First option is outright gifts. There will be no IHT due on any gifts that you make as long as you live for 7 years after making them. If you die within 7 years of making a gift, there will be inheritance tax to pay. The key point is that if you survive 7 years from the date of gift, the gift falls out of your account for inheritance tax purposes. And if you don't survive the gift by 7 years, the full value of the gift will fall into your estate. And lastly, if you survive the gift more than 3 years, but less than 7 years, then the gifts are taxed on a sliding scale known as taper relief. So if you look at the 3 to 4 years, the gift is going to tax at 32%, 4 to 5 is 24%, 5 to 6, 16%, and 6 to 7 years, 8%. So by surviving each tax year, you are saving 8% inheritance tax on your gift.
Okay. And we've had a question actually, two around this. One is, can I gift to minors?
Yes, you can, but you need to do it via a trust option. It could be bare trust or it could be discretionary trust, but you can't do a gift outright.
Okay. And then somebody else has asked, does the value of the gift matter? Like if it's 5,000 or 200,000?
It doesn't. It doesn't. Of course, if it is lower gift, I'm going to talk about the other exemption, so that then the 7 years rules will not kick in, because we have annual allowance of 3,000. So if the gift is covered by the other allowances, then we don't need to look into the 7 years rule.
If I was gifted £100,000 by a parent, and they live for more than 7 years after that gift, then there's no inheritance tax payable by their estate ultimately when they pass away.
Yes, and I will talk about the exception, that one, because you can see it's a huge tax saving option, so that you can imagine that there are lots of anti-avoidance rule around that. And Julia asked, they said, can I gift a house to minors? The answer is yes, but not outright, and depending upon which trust option and how you are going to apply it. And also when it is a minor, there are lots of tax anti-avoidance rules to observe. So we need to talk about that. In principle, yes.
Okay, brilliant, thank you.
You're welcome.
And is that tax payable by me, or so it's not payable by the recipient, it's payable by the estate?
Yes.
If they die within 7 years?
Yes, but at the same time, HMRC has a right to ask the IHT from the donee. So because let's say your father, your parent has done lots of gifts, and when they passed away, there is nothing there. Only the 3 gifts which were made to you and failed because they couldn't survive 7 years, and there is nothing on the estate. They don't recall the gift, so that they can't say that we are taking the gift back and we are selling it and getting our money is back. They're asking you to settle the IHT.
Okay. And then we've had just another question around this. Can you gift a house or an asset to minors instead of cash?
I mean, it's the same principles, whether it is cash or a house or any type of asset. In principle, you can, but not outright. We need to opt for some trust options.
Okay. Okay, and then I think someone's asking about one of the exclusions here. Is 3,000 a year tax-free?
Yes, I am going to talk about that now.
Okay.
A little bit. I think maybe in 5 minutes.
Okay.
Exciting news are coming. Okay, and now we talk about the outright gift. So, however, in order for a lifetime gift to be fully effective for inheritance tax purposes, the donor, i.e. the person making the gift, must give the property away without any strings attached. If the donor retains a significant benefit or enjoyment in the property given away, it will remain part of his or her estate for the purposes of calculating the inheritance tax. These gifts are called gifts with reservation of benefit. For example, Elizabeth gives her castle to her 3 adult children who lives elsewhere. She transferred the legal title into their joint names. However, if Elizabeth continues to live at her castle rent-free, this is gift with the reservation of benefit, and the property remains in her estate for inheritance tax purposes, or if Elizabeth releases her reservation, for example, by moving out of the castle or starting to paying her children full market rent, then 7 years clock will start running from the date on which Elizabeth released her reservation. Of course, there is some scope for a very minor reservation of benefits. For example, the donor pays social visit or stays temporarily at the house giving away, or the donor is giving the occasional lift in a car giving away. There is no gift with the reservation of benefits where the gift is exempt from IHT. So for example, gifted spouse or a civil partner are exempt. So we don't need to look for whether there is a gift with the reservation benefit rules applies. Michelle, new slide, please. Or we are already on that slide. No, one before, sorry, my mistakes.
Oh, that one.
Yes, exactly that one,
Okay.
Sorry. Gifts out of excess income is another option. Under this heading, there is no limit to how much you can give tax-free, as long as you can afford the payments after making your usual living costs and you pay from your regular monthly income. This is known as normal expenditure out of income. Regular pattern of giving is required. For example, meeting the annual school fees for grandchildren or paying the premium on a life insurance policy for another benefit. The first gift in this series can qualify, provided that the further gifts are intended. If the donor dies before making the second gift, there must be a sufficient evidence that he intends to make a series of gifts. Another option is to utilize the exemption and the relief. You might consider taking advantage of them. So annual allowance of £3,000, which can be rolled over only 1 year. So the £6,000 may be gifted free of IHT if you haven't used your annual allowance in the previous tax year. A second one is small gift allowance. Lifetime gifts of up to £250 to any one individual during a tax year are exempt. However, the exemption is only available if the gifts or the gifts to that individual doesn't exceed the £250 in total. You can make a gift of up to £250 to more than one person. It is not possible to carry forward any unused portion to the next year, unlike the £3,000 annual allowance. Gifts on occasion of marriage. Each tax year, you can give a free, tax-free gift to someone who is getting married or starting a civil partnership. You can give up to £5,000 to your child, £2,500 to a grandchild or great-grandchild, or £1,000 to any other person. Michelle, I assume that somebody asked me about this. Is it £3,000 a year? Did you say it's tax-free? When I say tax-free, I meant inheritance tax-free, yes.
Okay.
And the Faith asked, can you gift ISAs? Yes. Is an asset, is a bank account. If the ISA is less than 3 grand in it, then is in terms of your between your annual allowance. And if you are gifting £6,000, then you need to look at your previous tax year, whether you used your annual allowance. And if it is more than 6,000, then the up to 6,000 is going to be tax-free, IHT exempt, and other is if you survive 7 years is going to be completely IHT free.
Okay, great.
Can I continue?
Yes, go ahead.
Okay. And lastly, now I would like to talk about gifts to charities. Gifts to UK charities and the registered community amateur sports clubs are exempt from the IHD. So there's a charter exemption, basically. But this applies to the charities. But further, where at least 10% of an estate is left to a charity, then the rate of the inheritance tax applicable after exemption and relief reduced from 40% to 36%. So you are saving a 4% inheritance tax. The lower rate can apply only if part of the estate is chargeable to IHD at a rate other than 0%. In other way, where the 40% rate will apply to the value of the next estate in excess of the nil rate band after deducting the exemption and the relief and the residency nil rate band. So what we are doing, we are looking at the gross value of the estate and then taking it, deducting the nil rate band, deducting the all other exemption and relief and the residency nil rate band, and then looking at the 10% of that amount. And if you gifted over 10% of that amount, whole estate is going to be taxed at 36%.
Okay.
And in some circumstances, when you gift to the charities, because any gift you left to charities are IHD exempt, plus if that amount is over the 10% of your net value of your estate, and you also get the 4% discount, actually you save more tax than the monies that you gave away to the charity.
Okay. And we've had a question here from Fiona. If you are gifting 3,000 into an ISA for your own child, this part of your own 20,000 or on top of it?
Sorry, I didn't understand the question.
So Fiona's asking, if you're gifting 3,000 into an ISA for your child, is this part of your own 20,000 or on top of it?
I'll take that question. I think there's a little bit of confusion there. So everybody can have an ISA, and that £20,000 allowance is specific to you as an individual. It's an income tax allowance. Children can have what's called JISAs, junior ISAs, and you can make a gift using your annual exemption into their JISA. It's separate. It will not eat into your personal ISA allowance, and it will not be subject to inheritance tax so long as you stick to the £3,000 a year annual exemption.
Is that clear, Fiona? Yeah. Okay. Brilliant. Thank you. All right, Tulin, you can carry on.
Yes, I think I have finished my side, and now over to Louise, if we don't have any other questions.
Next slide, please, Michelle.
There we go.
So I just wanted to touch, just to sort of bring everything together, probably another main document that people should be thinking about is lasting powers of attorney. And, you know, just so for people that are not familiar, in the UK we have two forms of lasting powers of attorney. One is for property and financial affairs, and one is for health and welfare. So the property and financial affairs power of attorney will cover things like your house, your bank accounts, whereas your health and welfare power of attorney, that will cover things, you know, where you live, how you'll be cared for, who will make decisions about end-of-life care for you. And each document allows you to appoint persons to act on your behalf, so they're called attorneys, and it gives the attorneys very broad powers to do almost anything that you could do yourself in relation to your property and financial affairs. And again, the health and welfare lasting power of attorney, it gives the attorneys the power to make decisions about where you live, your daily routine and care, and it also specifically gives attorneys the authority to be able to give or refuse consent to life-sustaining treatment. So in the absence, if you don't have any of these documents in place, people closest to you cannot participate. You know, they will speak to medical professionals, but they won't be able to really influence any decision relating to our end of life care. So they're really important documents to have in place. And I think one of the main reasons why is, you know, if we look at, there was a recent Alzheimer's UK report saying that 1 in 14 people over the age of 65 are living with dementia. And I think we're a healthier and wealthier society, and people are living longer. So there's a greater need to protect against incapacity, because it's unfortunately something that a lot of us will come across in our later life. Probably another important thing to think about in the context of these two documents are that, especially if you're an entrepreneur, you might want to think about separating out your personal affairs and your business affairs. And it's, you know, especially important for entrepreneurs to think about who they would like to appoint as their attorneys for their personal property, their personal financial affairs, and their business affairs, because it might not necessarily be the same people in both cases. You know, a cliched but obvious example of this might be an entrepreneur appointing their spouse as their attorney for personal property and affairs, but a business partner or key information holder in the business as their attorney for their business affairs, you know, all affairs strictly relating to the business. And it really comes down to who might have the necessary skills and experience and business acumen to be able to handle that role. And it is really important to carefully plan for that, because if the worst was to happen, you want to ensure that the correct people are in place, that investor confidence is maintained, and the business is able to continue operating as normal. You know, if in the absence of this, if you haven't put a power of attorney in place, you haven't appointed the correct people, it would have an immediate detrimental effect on the business, on normal business activities. It may even seriously affect the value for a potential sale or exit. So it's really important to think about not only your personal affairs, but also the business as well. And making sure that the right people are chosen to act as your attorneys, because they're potentially, you know, in a personal capacity, the people you appoint under your personal lasting power of attorney, they're going to be the ones having potentially extremely difficult conversations with medical professionals about end-of-life care. But equally, on the business side, if anything was to happen to you, perhaps, you know, one case a colleague of mine had recently was a sale of a business was going through, and unfortunately the owner of the business had a medical procedure under anaesthetic and unfortunately slipped into a coma. So it really held up everything to do with that sale, because they didn't have a lasting power of attorney in place. And I think that really demonstrates how important it is to get it right and ensure that the best people are appointed to act as your attorney. You know, and it becomes even more important when business interests are involved as well.
We've had a question about whether or not your spouse, if your spouse is a director of your business, do you still need a power of attorney?
It's always advisable to have a power of attorney, you know, because the powers of attorney, they're not just effective on death. You can put them in place now and they're effective immediately. If there was perhaps a circumstance where you were not available, perhaps you're abroad or having a procedure, then it means that your attorneys can step in and sign documents on your behalf and act on your behalf, you know, even in a context where you're not lacking capacity, where you're just not available for whatever reason.
And Monique has asked, as a business owner, who inherits outstanding salary, dividends, etc., and would a lasting power of attorney need to be in place?
So that would, your estate would, whatever is due to you would be inherited, would pass to your estate, and your executors would administer that after your death. A lasting power of attorney is a lifetime document. So it's something that you would put in place to deal with if you had during your lifetime, to deal with any affairs within your lifetime.
Okay, great, thank you. Brilliant. Must I move to the next, is there a next slide?
I think that draws our presentation to a close, really. So we're happy to take any further questions. I know we've had quite a lot of questions already, and I think you mentioned, Michelle, that there's quite a few specific questions. But yes,
so yeah, there's one here. So someone said, I'm currently going through estate planning with my husband. As we got married later in life, there's more than one property to divide between children and godchildren. Our solicitors advising that we cannot leave property A to child A and property B to child B, for example, but that we have to apportion a percentage value of the estate to child A, child B, etc. So it appears we have no say in which properties end up in whose hands. I'm very confused by this.
Yeah, that's not correct. That's, unfortunately, you've received some poor advice there. You can leave specific legacies of property within your will. If you didn't want, so essentially what happens on your death, all administration costs and expenses and taxes are paid, and everything will fall into one pot called the residuary estate, and then you can distribute that as you wish, usually in percentage shares, for example. But if you specifically wanted particular properties to pass to specific individuals, you would do a legacy of property, making it clear in your will exactly who you wanted to receive what assets.
That's brilliant, thank you. And I'll ask, because that was a direct message to me, so I'll make sure that you can be connected afterwards, so to get more clarity on that. Someone's asking, is it important to put life insurances into trust?
Yes, it's exceptionally important, because if life insurances, life policies are not written in trust, they will be payable to the estate. So they will be added to all the other assets in the estate and subject to inheritance tax at 40%. So it's really critical to make sure that all life policies are written in trust, and then they pass outside of the estate on death.
Okay. We've got a question here. There's a lady who says she's having an issue on a matter that she needs to resolve. I have a beneficiary in my will who needs to be compliant from a FICA perspective. She is a silent beneficiary, meaning that I do not want her to know that she is to benefit. However, the POPI Act necessitates her knowledge in order for her to supply personal documents for compliance. How do I navigate this?
It's completely a USA tax question.
Okay.
We have some clients in those areas, and we have a specialty in our team. But in the UK, you don't have to tell. They can learn when they pass away. But if it is required by the USA law, they need to get a tax advice there.
Okay. And then Faith has asked, I worry that when I'm gone, my husband can remarry and my children may lose out, although my husband's estate will get, although my husband will state I get everything. So I feel a bit guilty, but am I imagining the worst? What's your advice?
It's, unfortunately, it's a situation that I do come across quite regularly. And one thing that people don't appreciate is they might think, okay, I've died, my husband has gone on, he will put a will in place to make sure that our children benefit, but then he meets somebody and he marries. And one thing people forget is that marriage revokes a will. So any documents that your husband had in place before that marriage will be automatically revoked by that marriage. So it's something that you really have to think carefully about. And unfortunately, I do come across situations where children from a first marriage have unfortunately missed out on inheritance from their deceased parent because of remarriage.
Is there a way to exclude that? Can you provide in your will that if your husband or wife remarries, that that your children will, that's ring fenced for your children?
So I mean, the very basic answer is to leave everything to your children directly, but you wouldn't want to do that because there's tax consequences to that. Gifts to children will be subject to inheritance tax, whereas any gifts to spouse a tax exempt. So I think I talked about it a little earlier about how one way of structuring your will is to leave your estate on trust, give your spouse a life interest in that trust. In doing so, you secure the spouse exemption from inheritance tax, but it just means that the capital of your estate is preserved for your children. So it's a really good way of making sure that you know, your spouse can still carry on living in your home. They could even rent out the home and take that rental income, but the house itself, the main capital assets, are preserved for the children.
Brilliant, thank you. I think we've got, oh, we're actually bang on time, so I think we've run up, but we did manage to get through all of the questions, I think. But what we'll do as part of the roundup is I'll send everyone a link to the recording and loop you both in on the email, so that if anyone does have questions, they can follow up with you separately. Thank you so much for a really, really knowledge-packed session. Faith, I was just saying you will receive, you'll be linked in with Tulin and Louise via email. But thank you both so much. That was incredible, really, really detailed. And I think we've fitted so much into the last hour. And I'm sure that everybody is now suitably incentivized to sort out their thinking around what they would like to happen with their estates. And also taking all of those tax considerations into account, which I think, so it's been really, really valuable. Thank you so much to you both. And everybody agrees.
Thank you for listening us.
Thank you.
No, brilliant, thank you. And am I correct in saying that if anyone does have any questions, they can contact you directly? There might well have been people on today who haven't wanted to share a question in the chat, so we'll get them to contact you directly. But thank you both so much. It is such an honor for the Women's Chapter to partner with Collyer Bristow and to have access to expert legal advice and incredible resources like what you've shared with us today. So we're really, really grateful. And I would encourage everyone to get in touch. I have worked with Collyer Bristow on the evolution of the Women's Chapter and making sure that we're protected around that. And now it seems very clear that I need to do so from a personal perspective as well when it comes to my estate. So thank you so much, Louise and Tulin, for everything that you've shared with us today.
Thank you. Thank you.
Thank you for joining us, everyone. Have a wonderful afternoon.
Thank you. Bye-bye.
Bye. Bye.